Hi, my name's Daniel Barron. I'm the webmaster of New Forest Hog. That's a chapter of the Harley Owners Group. It's based in Southampton. I'm one of the 3 people that are doing all the work to bring our club up to speed with GDPR, and spent a lot of time researching the impact, the liability, the things you need to do, etc. And it's been quite hard to find information specifically for a non-profit club such as a Harley Owners Group Chapter. There's lots of information about marketing, loads and loads about that, but just kind of getting something concise, specific to non-profit clubs like Harley Owners Group Chapters. So I've gathered together lots of notes, and I'm going to go through my notes and hopefully that's going to help you. By the way, I've got 25, 30 odd years experience in IT. I've been a company director for 13 years. I've created multiple award-winning bits of software myself. I've led teams, and I'm currently looking for employment. If you are a recruiter, don't bother. So I'm based in the Southampton area. Anyway, on to the stuff that you really care about. So this is to basically tell you everything that I've learned about GDPR, how it applies to not-for-profit clubs and organisations. It's not everything that you need to know, but it's a really good start, and it does cover a hell of a lot of stuff. And there's going to be some eye-openers here. So GDPR means that if you're an organisation or a business, but we're talking organisations here, and you control or process personal data of someone from the EU, you've got some major legal obligations or risk hefty fines. So I'm not going to cover the basics of GDPR. There's plenty of information available, including on the ICO's website itself. I'll include a link below. What I'm going to cover is specific to the not-for-profit club scene. So, first, you probably care about this the most. Are you going to be liable? Are you personally liable? If you are a committee member or trustee or whatever of the club, are you personally liable? And unfortunately the answer is quite possibly yes. You might be saying, but we're just volunteers. Yes, so am I. We don't get paid. No, neither do I. Doesn't matter, doesn't change it. What matters is the legal status of your club. It depends on if the non-profit is incorporated. If it's unincorporated, then the committee members or the trustees carry joint personal liability. That could be you. That type of organisation that's unincorporated has got the least legal protection, regardless of whether it has a parent company, such as, for example, if your club or chapter is owned by, say, your Harley Davidson dealer. Doesn't matter. If it's incorporated, the organisation, as in the would be liable, and thus the dealer, not you personally. So what you need to do is check your governing document, see if you're not sure, and my advice would be to choose an incorporated legal structure. I'll put a link below about legal structures and liability in general. Okay, so yes, you're probably going to pause the video now and rush off and try and find out if you're actually liable. But the next thing is, how much will you be liable for? 20 million? That's the kind of numbers that have been bandied around. Honestly, the chances are exceptionally low. I base my opinion on that based on a video by a multi-award-winning business lawyer and data protection expert called Suzanne Dibble. I'll provide a link below. So you're basically going to need to get a court first, and that will happen when someone complains to the ICO. So that's the UK's governing body for GDPR. So you don't want to do anything that you shouldn't with your members' data to cause any kind of complaint. But even then, if you can show that how you're improving things, how you're moving towards full compliance, the more likely you are to simply have a reprimand and not a fine, and just be given guidance on how to do things better. So it's not as scary as some people have been making it out to be, but it's still pretty serious. Like I say, I'll provide a link to that video where I cite where I get my source from. So what kind of data is personal? So we know things like personal information, names, email addresses, photographs, age, address, IP address, although IP is only when it's associated with other data. So the IP address comes from when sort of visiting your website, for example. But anything relating to an identified or identifiable individual, but also things like if anything in connection with the registration plates of motorbikes. The registration plate is considered personal data and as such is protected by the GDPR. For example, also data relating to journeys made, parts used, dates of technical checks, numbers of kilometres or miles or style of riding are effectively personal data when they can be linked to an individual. So that's probably more than you thought. So you need to bear that in mind. It's quite wide-reaching. So I'm going to go through a whole list of things you need to do and bits of information. It's a bit of a hodgepodge, but let's go through it. So first, you're going to need, ideally, you're going to need a GDPR statement for your website that links to your privacy policy. So that's basically saying, yes, we're GDPR compliant, blah, blah, blah. There's plenty of examples online you can find. Technically you don't need the statement, but it's a good idea to have one. But one of the biggest things you're going to need to be doing, other than looking at process and looking at the data you hold and how you manage it, is you're going to need to update your privacy policy a lot. It needs to be really explicit about the data you collect, what you do with it, if you transfer the data to third parties such as MailChimp, your website hosting company, Google for G Suite, Google Analytics, suppliers, any kind of companies such as maybe the campsite you might use for your rally, etc. You need to basically be explicit. And on that privacy policy, you need contact details about how to make a subject access request, or exercise the people's right to be forgotten, or indeed the right to withdraw consent. Also, you want to include how long you will retain the data for. Perhaps it's going to be different lengths according to type of data, and you will need to include their right to lodge a complaint to the supervisory authority, that's the ICO in the UK. Your privacy policy also needs to include what legal grounds you will be processing the data on, such as consent, legal, or maybe legitimate interest. Where it's legitimate interest, I'll explain a bit about that later. Where it's legitimate interest, legal, or anything that's not explicit consent, you need to include why. You need to spell it out. And so that's that's your privacy policy wrapped up there. But in order to know what you do with your data and who you share it with, you're obviously going to need to do some kind of internal audit and ask all your committee members what data they hold, why, etc. Maybe cut that amount down, look at how you manage it, store it, etc. But that ultimately will lead to your all the information you need for what you do with it for the privacy policy. So, and in terms of using the privacy policy, at the point of collecting data, such as on a newsletter sign-up form, or a membership form, or online store checkout, the privacy policy needs to be upfront, visible, clear. A little link at the bottom of your website isn't good enough. It's got to be clear there, visible at the point of collection. So, next. Any third party that you share personal data with must be GDPR compliant. And you will need a written processor contract, or possibly also a controller contract, depending on what they're doing with the data, with them, or their GDPR compliance needs to be clearly rolled into the terms of business. So the point is, you need some kind of written contract with the people that you share data with, or have managed your data for you. So, and of course, if you're going to share data with someone, you need a legal basis for sharing the data, and you will have obviously mentioned it on your privacy policy. I'll include a link about the contracts from the ICO's website. Okay, next point. Regarding retaining data, you should only be keeping the data as long as is necessary for the processing. That's the wording. Is as long as is necessary for the processing. So on top of that, you've got other aspects, like you may have legal requirements. You may need to retain the data for 7 years for accounting purposes, or other kind of legal purposes. Maybe it's some kind of liability sign sheet that you have for ride-outs. You're going to want to keep that for a certain amount of time. Maybe you've got annual mileage competitions. You're going to need to keep the data long enough to know who's won. The club may have an online photographic history, in which case you're going to need to keep the photos for a very long time. But there needs to be a reason. You know, it has to be necessary to retain the data for the processing. If you don't need the data, you shouldn't be keeping it. So something like an annual purge of membership information over 2 years old is a good idea. I say 2 years because you think about it logistically, you've got the current year and you've got the previous year, and maybe you've got some kind of renewal fee or whatever, so you're going to need the data for 2 years. It's as long as it's reasonable, then you can keep data. So once you've done all that, you're going to need to contact your existing club members to let them know that what your updated privacy policy says. You will also want to update your membership forms, so there's an explicit opt-in to be emailed for your email newsletters. Technically you don't need to do this because there's legitimate interest, but you shouldn't rely on legitimate interest. It's better to have consent. So what do I mean by that? So legitimate interest covers you for where processing data is required to conduct the business for you or the third party. For For example, if you've got an online shop or a club magazine and the members expect the magazine posted to them, then you don't need additional consent to process their name and address because it's a contractual obligation. But it's not something to be abused. You can't take additional information or share their information beyond what's needed to fulfill the contract without additional consent, that is. So legitimate interest will cover you for most of your club activities in terms of permission to process. Also remember that if you need the data for any kind of legal reasons, you don't need additional consent. One example is statutory accounting. I mentioned that earlier. Ride-outs, again, I mentioned earlier. Ride-out liability forms, because you want to keep them for a reasonable length of time in case of an accident and litigation. So, back to some newsletter stuff. If you've got any marketing style emails, so maybe you're advertising your rally, you're going to need to make sure that you've got a recorded opt-in for marketing style emails. So this means you need to email all your existing contacts from maybe previous rallies and ask them to opt in again, and then after the 25th of May you can only email those that were specifically opted in. Okay, next on website. If you've got a website and on that website you've got a store, even one without payment mechanisms, or a website where members or visitors can create accounts, it's going to need to be secure. You're going to need SSL certificate and sensible security around the data you hold. Okay. Another thing to do. Yeah, you probably want to, hopefully you've got a pen and you're writing this all down. You need to do an internal audit of which committee members have got what kind of data, how they store it. The data must be reasonable, so it mustn't be more than you need, more detail than you need. It must be stored securely, be it on paper in a locked filing cabinet, or encrypted with a password on a computer, or shared with secured accounts in the cloud, such as on Google Drive on G Suite. Okay. Any device like your phone or PC must have a password or a PIN to use it, or some kind of password and PIN to access the data itself. For example, if you can access the private data in your web browser or an app on your phone, then if someone can gain access to that without needing a password, so you leave your phone lying around, it doesn't have a password, and it's got the password for access data cached, that's bad. You need to have at least a PIN on that kind of thing. Another one that's going to be a bit of a pain for not-for-profit clubs that are full of volunteers working on a shoestring. You really don't want to mix personal and club business systems together. So if you use personal email, then the data that you've been effectively storing and processing in your personal email, it can't be adequately managed. So what you really need to do is you need to use a commercial email storage, document, whatever, collaboration tool, such as Google G Suite. The free tools like non-commercial Dropbox, personal Gmail, etc., they're not going to be compliant. Dropbox themselves have said that only the commercial ones are going to be GDPR compliant, for example. And personal Gmail, well, Google get the money to provide that by basically looking at email to be able to provide you personalized ads, all that kind of stuff. You don't get anything for free. So what you need is a commercial system, and then just keep everything in there and keep it separate. It's okay to have on your phone, say, using Inbox, Gmail app, whatever, you can have both accounts on there, a personal account and a club account. That's absolutely fine, that's not a problem, as long as your phone's got a PIN or whatever. But the point is, don't use your personal email, your personal Dropbox, personal whatever, for club business. Keep it absolutely separate, and then it's really cut and dry. Okay, so now all your treasurers are a bit upset for your clubs, because you're probably going to have to spend some money. Okay, next, you need to do some kind of internal training, so that all your officers, your committee members, etc. are aware. By just keeping the files in a commercial system like G Suite, not spread around different places, actually ticks lots of the boxes of the compliance about security, audit, search, deletion, etc. So you want a reasonable amount of internal training. Link to this video maybe to them, or there's plenty of other videos about GDPR that are much shorter. So for an organisation, so on data protection officer aspect next, for an organisation like a motorcycle club, where you've got less than 250 employees, is roughly what the rules are, you're not going to need a data protection officer. But you do need someone nominated as a point of contact for any data protection queries. This could be, for example, just the info@ address that you've probably already got. In addition, you'll need to have some kind of known process for data subject requests and deletions, corrections, and for breaches. And if you have a breach, you're going to need to let the affected people know, as well as the ICO, within 72 hours of that breach. For a data subject request, you need to reply within a month. On data subject requests, what's really important is that when someone is making a request, that when you reply, that you're replying to the person that owns the data. It could be a phishing attack, for example, and you'll end up with a data breach. So make sure that they legitimately own that data and they're really who they say they are, before you actually give them the private information. So if necessary, you might want to ask for proof of ID, such as a copy of passport and things like that. So next point on these kind of requests, the data subject requests, is you only need to send personal data. You don't need to send reams of emails that they once sent you. You only need to send those with information that identifies them. Personal data such as address and so on. You don't need to send every single email just because it's got their name in it. You only need to show that you've got their email address and you've got their name. And any emails that with information in that is specifically personal, like address. Now, further on requests, you can and should withhold the personal data if providing the personal data to the person who has rights to the data would adversely affect the rights and freedoms of others. So if you're going to be if someone's asked for some personal data, by providing that personal data, you are giving away some private information about someone else, then you can refuse. So if you've got internal emails bad-mouthing someone, or some kind of internal dispute where a third party's identity or other personal data will be revealed, you don't need to provide that. So the key point there is, if you're providing the data to the person who's got rights to that data, it mustn't adversely affect the rights and freedoms of others. Okay, I'll provide a checklist for this kind of request in the link below, one of the links below. Okay, final point on requests. You used to, this one is a pain. You used to be able to charge a fee of £10 per request. You can't anymore. Not as of 25th of May. It has to be free, which really sucks when you're a volunteer, you're unpaid, you're doing this in evenings or weekends, and some person sends you a data subject request, and you've got to spend ages finding information, and you're thinking, I'm not even paid for this. Yeah, and because now you don't need to pay for it, that small amount would have been enough to get rid of a number of people just wasting your time. That's a shame. So, but you can refuse if the request is manifestly unfounded or excessive. Yeah, that's the wording. But if it is excessive, you can charge a reasonable administration fee. You can also refuse. Give your grounds and ask that they raise it with the, escalate it basically to the ICO instead. Okay. Right. Final point on this video is about photographs. So photographs are now classed as personal data. They're subject to GDPR and also obviously existing privacy laws. So you're going to need some consent or other grounds for taking them and processing them. Consent can be obtained by being spelled out in a privacy policy, which of course you'll now be getting your members to agree to as part of joining a club, won't you? Yes. Most likely though, taking photographs of people at events or public events would come under legitimate interest. If you're taking photos of club events for the purpose of showing them with your club, for historical purposes or for advertising what your club does, then it's clearly in your legitimate interest to be doing so. And in fact, people who you're taking photographs of are probably pleased to appear on the club history. However, legitimate interest with photos is a very grey area. It's untested legally. If you can get consent, that is the best thing. So, but interestingly, consent can be given verbally. So, people happily posing for a photo that they expect to go on social media, the club's website or magazine, they are giving explicit consent by posing like that. If someone's clearly unhappy about being photographed, then they're not giving consent, and you shouldn't do it. So, but your photographs may not impact on the rights and freedoms of those that you are taking the photographs of. So catching a member of the public doing something that they would not want to share is strictly not allowed. You'll need to use your discretion. You need to balance the consent and legitimate interest with people's privacy. A good way to think about it is if would they expect their data to be captured and processed in the way that you intend to. And don't forget, people can withdraw their consent. Don't take photos of people who explicitly told you not to. Okay. Right, so that wraps up everything that I currently know about and have found out and researched thoroughly about GDPR and how specifics to do with non-profit organisations such as motorcycle clubs and that kind of organisation. Feel free to share. Feel free to ask questions. I'll do my best to answer, and I'll include a bunch of links below as well. Alright, thanks for listening.